Good evening, everyone, and thank you for joining us this evening for our panel discussion on borders, racialization, and refugee protection in Rwanda. This is the second in a series that Professor Catherine Briddick and I are hosting on the recent UK Supreme Court decision in AAA, Syria and others, which was handed down on the 15th of November this year. Tonight's discussion is co-hosted by Refugee Studies and Border Criminologies in the Centre of Criminology at the University of Oxford and the Dickson Poon School of Law here at King's College London. I'm Dr. Nicola Palmer. And it forms part of mine and Catherine and Professor Elpa Palmer's thematic work on law and courts within border criminologies. And we're really delighted to be able to host this discussion this evening. As I'm sure many of you on this call are aware, on the 15th of November, the UK Supreme Court held that there were substantial grounds to believe that a person seeking asylum in the UK, if sent to Rwanda, would be at real risk of ill treatment by reasons of refoulement. The risk would be that people whose applications for asylum are assessed in Rwanda could be sent back to a country, directly or indirectly, in which they would be subject to human rights violations and ill treatment. As discussed by Raza Hussein, KC, Professor Catherine Costello, and Dr. Madeleine Garlick in a panel discussion last week, the decision has been welcomed for its clear endorsement of the centrality of non-refoulement as a core principle of international law. And in determining this risk, however, the evidential basis of the judgment turns on the court's assessment of Rwanda. The decision is based on an assessment of the general human rights situation in Rwanda, the adequacy of its individual refugee determination process, the independence of its judiciary, and its compliance with assurances given under similar migration arrangements. Today, we are going to keep a focus on Rwanda, but I'm hoping we will widen this lens to ask the question, what impact has the Migration and Economic Development Partnership, which has been deemed by the Supreme Court to be unlawful, but was initiated in April 2022, had on Rwanda to date? In particular, to use the Supreme Court's own phrasing, what impact has it had on Rwanda's open door policy towards refugees, moving within the Great Lakes region in particular? And in addition, how might we then understand this agreement within a longer colonial history of the UK's use of enforced removal or deportation as a mechanism of controlling and racializing the movement of people? Now, to explore these themes, I have four wonderful panelists, all of whom I will introduce now, and we're very grateful for their time. First, we welcome Honorable Dr. Frank Habineza, who is the founding president of the Democratic Green Party of Rwanda and has served as a member of parliament in Rwanda since September 2018. Dr. Habineza ran as a presidential candidate in 2017 in the Rwandan national election, representing the Democratic Green Party of Rwanda, and has indicated an intention to run in the upcoming elections scheduled for August 2024. Dr. Habineza is an environmentalist, a human rights, democracy, and defense security expert who graduated from the National University of Rwanda in 2005 with a BA in public administration, followed by a Master's of Science in Politics and War Studies in the Swedish Defense University in 2017. He was awarded a Doctorate of Humanities in recognition of his work in democracy and human rights by Bethnal College in Indiana in the USA. We welcome you, Dr. Habineza. Thank you for your time. He will be following from his contribution. We will then turn to Dr. Uttara Shahani, who is a developmental lecturer at Refugee Studies at the University of Oxford. Uttara is a historian whose work examines the history of colonial South Asia, partition, and refugee regimes. She currently teaches on post-colonial borders and forced migration and recently completed a British Academy-funded project with Dr. Anne Afford on borders, global governance, and refugees, examining the historical origins of the global refugee regime with a focus on South Asia and Palestine. And she will be joined by Professor Michael Collier from the University of Sussex. Michael is primarily a political geographer with an interest in the relationship between people on the move and states. His research focuses on 3 areas: undocumented migration, detention and return, forced migration, internal displacement and refugee movements, and the geopolitics of migration control. Alongside his extensive set of academic publications, he's conducted a wide range of research consultancies for UN bodies and national governments. And finally, I will hand to my friend and colleague, Dr. Felix Mukizwa Ndahunda. Felix is a researcher, consultant, and honorary associate professor at the University of Rwanda's College of Arts and Social Sciences, and a research advisor for the research, documentation, and policy engagement at the Aegis Trust. He previously worked as an assistant professor at Tilburg Law School and as an associate legal officer for the International Criminal Tribunal for Rwanda. He holds a PhD from Tilburg University and has lectured and published extensively on the intersection of law and peace, conflict and justice in Africa, with a particular focus on the Great Lakes region. So thank you to all my panelists. I very much look forward to the discussion that we will be having today. Dr. Habineza, let me now hand to you.
Yeah, thank you very much. Indeed. I'm also very, very pleased to be with you this evening, and to all the audience and to all the honorable presenters we are together. Yeah, well, the issue of the UK migrants being sent to Rwanda has been very kind of, let me say, hectic. So it has been received with mixed reactions, both in Rwanda but also outside Rwanda. There have been some voices which have been supportive, and other voices which have not been supportive, have been opposing. I happen to be on the side of those who have not accepted or have been opposing this policy. But perhaps first, I will explain a little bit about Rwanda's refugee policy. Rwanda, like any other country, has signed on the UN Convention to receive refugees, the Geneva Convention, and receives all refugees that come to it. We have many from Congo, others from Burundi. I think at the moment we have over 100,000 refugees in Rwanda. There are others also who may come from other countries. I know for sure that there are some who have come from Afghanistan, who are here. And the other countries, I think you have heard about this, the Eastern Powers in Rwanda. So there are so many. So this is quite a good strategy. I mean, like every country has the responsibilities and challenges to that, but UNHCR, United Nations Committee for Refugees, is a good partner in that. Now, there has been another instance. I think you've heard about the Libyan refugees, or the refugees who have been stranded in Libya. And those ones, they were discovered when President Kagame, President of Rwanda, was chairing the African Union. He had information that these people were trying to, but were stranded and imprisoned and enslaved in Libya. And no one was willing to help. And as you know, many crossed the Mediterranean and most died into the Mediterranean, not forgetting those who died in the Sahara Desert. So President Kagame offered to bring them to Rwanda, process them so that they can go with them. So with the help of the UNHCR and some other countries, here Denmark has been at other countries, we have built up a transit center in one of our districts. And so they have been processed. Most of them, they stay for some 2 months, 3 months, 4 months, and they go to their countries, other countries, according to the UNHCR agreement here. So that has been a good thing. So we were very surprised when the UK, based on that, and decided not to take their responsibility of receiving the refugees or the people who are running to the UK that they wanted to send them to Rwanda as a third country. And this time, not for processing, but to stay. Or if not to stay, then perhaps they would be sent back to their countries. So we as a party, the Democratic People of Rwanda, were not happy with this. We said, well, we think that this is not the right thing because the UK is actually quite a bigger country, a bigger economy than Rwanda, and with a lot of resources and much more employment opportunities for people other than what we have in Rwanda, whereby we have many, I think over 20% young people here, and many other challenges. So we said that clearly, people, if they come to Rwanda, even though it was this big money, $100 million, I think, dollars, which was signed to first help receive them, but it was just for 5 years. So after the 5 years, then that means the people would be the responsibility of Rwanda. We said, well, Rwanda is already overburdened. You know, we are the most densely populated country in Africa. So this is something people underlook, but that means that even we have very limited land to build our houses. So we say here, this is not the country, the most densely populated country in Africa, to be the one to receive, put off the UK. So we as a party, we decided to do that and have been very focused on that and crushed with some other people on that. But I think we have maintained our stand, and we were also very happy with the Supreme Court, the UK, and the Court of Appeal of the UK, who also took reason from what we have been saying and decided, and especially also the European Court of Human Rights, which also decided not to send those people. We are very happy for all those decisions, but especially the Supreme Court's decision not to send those people to Rwanda. So we think that the UK should take responsibility. So a few remarks. I'll stop here if there are some questions.
Thank you, Dr. Habineza. So you picked up a point there in relation to responsibility sharing. And what do you see as Rwanda's current engagement with responsibility sharing in terms of their existing refugee processing and determination?
Well, Rwanda, as a country, they have, of course, provided security, they have provided housing, they have provided water and other things. And so they have been doing a lot of things to make sure that these people are secure. We have refugee camps. I mean, for those refugees coming from Congo, from Burundi, we have camps in Hama, in the eastern province, also in and other parts of the country. So the country does its part, and the UN provides, I think, the support allowance, the financial, but also they have other bilateral partners who also come in to help, and other international NGOs that come in to help with different aspects. I happened to the Seller Transition Center, and I saw that there were a lot of partners and countries that have been involved. And I think some of the partners, they share different costs and so on. But the country provides the infrastructure and the security and all the other technical necessary needs here. So that has been the part of Rwanda's share here on that aspect. But this, as I say, is different from what the UK wants Rwanda to do, because this part of Rwanda's obligation to receive refugees, not to receive refugees of those who went to another country, but those who come to Rwanda. We as a party, we are happy to receive those people. Those who want to come to Rwanda to receive refugees, yes, but not those who go to another country, say UK or Denmark or Germany, and then descend to Rwanda. Then that's not right.
Thank you, Dr. Habineza. I hope we can perhaps pick up on some of these questions as the discussion continues, particularly in relation to the non-forced aspect of that you've just touched on there. Let me now hand to Dr. Utara Shahani, please, to join the conversation.
Thank you for inviting me. I'm not going to speak so much on the implications of the Rwanda judgment, but to go back in time a bit and to very quickly speak in a sort of very bird's eye view, crude way about colonial practices of forced relocation in which perhaps the Rwanda scheme can be located. Without wishing to draw a teleology from one particular case study from history, one can see that the British Empire had patterns of expulsion, externalization, deportation, offshoring, dispersal, all with different names, and sending refugees to third countries to a place where they have no connection. And one also sees removal as a type of penalization. We talked about penalization as a legal category last week, where refugees were sent to penal colonies, perhaps the most outstanding example being that of the Black loyalists who were sent to Botany Bay in the 18th century. Offshoring migrants and refugees, notably those considered to be undesirable and at the bottom of racialized hierarchies, is part then of an extended history of colonial forms of thinking and practice on the physical location of racialized peoples. the colonial characteristic of regulating migration to propel it in specific directions while also promoting immobility. This is the other side of the coin. You send people somewhere and then expect them to be stuck there in some way or the other, is one we see in the early British Empire, but also well into the 20th century, especially when it came to the relocation of refugees to the colonies in the interwar years. And that's what I'm very briefly going to focus on in the next few minutes. Many scholars have done work on this in different ways. And as Joanna Newman has shown, the Foreign Office had repeatedly pressed the Colonial Office in the early 1930s in response to a request from the League of Nations to investigate the possibility of allowing some 10,000 Assyrian refugees who had been forced to flee Iraq to settle in Cyprus, East Africa, Ceylon, Mauritius, Seychelles, Tanganyika, Northern Rhodesia, British Guinea, Nyasaland, or Uganda. The League followed this with another request in 1935 to accommodate Jewish, Assyrian, Turkish, Armenian, Russian, and Tsar refugees in the colonies. These schemes did not come to fruition, and I think this is key. Often they don't come to fruition, but the idea is always there that let's send them somewhere. But during the Second World War, Britain succeeded in overseeing the relocation of large groups of people to areas with which they might have had no previous connection. The relocated refugees were those often construed as subaltern whites. They were not necessarily black or brown, and they were those who Jochen Lingelbach has replied as those who occupied the edges of whiteness. So, for example, the Polish refugees relocated to Africa from 1942 to 1950. The dispersal of poorer refugees and refugees considered of inferior status to colonized territories in the Caribbean, Africa, and India involved the continuation of a practice of relocating prisoners of war and refugees across the empire during the Boer War and World War I. The absence of a legal definition for refugee in the interwar years meant that the term was used flexibly to describe different groups, and the categories a displaced person occupied could shift. The Colonial Office was against plans to relocate the war displaced to the colonies, as were white settlers and administrators on the ground. Nonetheless, several colonies, including colonies in the Caribbean, Africa, British India, and Princely India and Australia, served as, in quotes, holding locations during the war for diverse populations, including Jewish refugees, Stalin's freed Polish prisoners, Czech, Hungarian, Italian, and Bulgarian prisoners of war, political prisoners, dissidents, and Maltese and Cypriot subjects of the British Empire. These groups could either be confined to specific camps or interned as enemy aliens. Indeed, refugees also occupied the category of enemy aliens. Dispersal acquired further compelling urgency after the war when decolonization became a tangible prospect in the 1940s. At this time, the UK did not want the displaced populations it had interned in the colonies to so much as transit through the UK to return home or to go to other countries. The Foreign Office went so far as to refuse to accept, for example, that the British had interned myriad groups of European displaced persons in India until the Commonwealth Relations Office produced, in quotes, chapter and verse evidence. And the Foreign Office then maintained that the solution was to simply shift the problem, in quotes, of these displaced persons elsewhere to geographically distant locations in still existing African and Caribbean colonies. The Caribbean, where the British had transported enslaved and indentured labor, was also a place Whitehall envisaged as a home for refugees it did not want in the UK, despite ongoing resistance to the idea from the Colonial Office. In 1948, the purpose of the Evans Commission was to investigate the feasibility of transferring and settling in British Guyana and British Honduras, which is Belize, so-called surplus Jewish refugees and, in quotes, surplus populations of other West Indian islands. Perhaps one can call this a version of burden sharing without the consent of the receiving countries or of the refugees, though you do find refugees sometimes in desperation consenting to these schemes. The British frequently justified colonial rule on the basis that the colonies were ill-suited to govern themselves. The purpose of colonial rule was to help the colonized grow into the qualities they needed for self-government. The idea behind developmental colonialism was that white colonizers would guide the colonized to better standards of living, as Lingelbach has shown. In the decolonizing world of the 1940s, in some cases, refugees were cast as the agents of this development. And here I think there's another very strong link to what we're seeing in the MEDP. but sometimes as competitors to local populations. The Rwanda scheme promised that it would, in quotes, enhance economic prosperity in the region by investing in upskilling, development, and projects which will benefit both migrants and their hosts. And you find that there is a very long history of this promise of economic development once refugees are moved. Can I have a minute more, or I'm time on? The racialized territorial and temporal restrictions on the Refugee Convention were lifted in 1967. However, merely a year later, 1968, the UK enacted the Commonwealth Immigrants Act 1968, popularly known as the Kenyan Nations Act, which sought to block the entry to Britain of East African Asians. The UK had already started to erode the right of Commonwealth citizens as opposed to white immigrants to enter the UK with the passage of the Commonwealth Immigrants Act 1962, when East African Asians began to leave Africa in response to Africanization policies that disenfranchised them. Their exodus peaked in 1972 when Idi Amin expelled them from Uganda. And I don't have to tell this audience, they know of the East African Asians versus the United Kingdom case, where they challenged this as discriminatory before the ECHR. The claimants were successful, but the commission found that some were British protected persons. So those who challenged the case, many of them were allowed into the UK, but there was this category of British protected persons who had no right of abode in the UK. And the commission held that the exclusion of BPPs from the UK was permissible, and then they became stateless refugees. And then the UK, with the help of the UNHCR, as Sarah Kozmans has shown, dispersed BPPs and other stateless East African Asians to at least 25 international destinations. So all these, as I've rushed through a lot of history in a very few minutes, but all of these, I think, provide a pertinent background to the direction that the UK's approach has been taking to post-colonial citizenship and asylum, and it has taken with the UK-Rwanda scheme in juxtaposing regimes of non-entree with regimes of dispersal or relocation.
Thank you.
Thank you.
Michael.
Thank you very much. It's a real pleasure to be here. I'm going to pick up where Utara left off, starting with the 1970s and the beginning of migration restrictions, significant large-scale migration restrictions in the UK. Deportation is obviously about the movement of people, the forced movement of people, but it's also about developing, reinforcing hierarchies between people and between places. And I think this is the element where the colonial analysis that Utara has undertaken relates directly to what we're talking about today. So I want to talk about each of those, about the movement of people, but also about this development of hierarchies. In terms of movement of people, the MEDP is a very significant departure from what has been undertaken since the 1970s. There's been a significant development of enforced removals, as it's called in the UK, in relation to particularly people seeking asylum who've been rejected from the asylum system since the end of the 1990s. In 2001, there was about 2,000 people who had been through the asylum system who were forcibly removed, and that had been more or less the same numbers throughout the 1990s. That started to increase in quite significant terms in the 2000s, peaking in 2011, and has subsequently fallen since then. In almost all of those cases, people were removed directly from the UK to their country of citizenship. In a smaller number of cases, people were removed to countries that it had been demonstrated that they'd moved through. But the MEDP marks a really significant departure from this practice by moving people to countries where they had had no connection before. They'd never spent any significant amount of time. They'd never even been to in many situations. So there are a number of other examples where this has been experimented with. The Australian, what's often called the Pacific solution, is one example. The Italian government is currently developing a similar system to move people to Albania. But in these situations, people are moving under the jurisdiction of the country that is moving them. Whereas under the MEDP, there is really a wholesale shift of responsibility from the UK to, in this case, Rwanda. And this relates to this shift in the hierarchy between people and places that deportation more broadly, but the MEDP more specifically, also starts to contribute to. I was particularly interested in Nicola Palmer's blog, Judging Rwanda, which makes a very similar point, that the judgment highlights the deficiencies of the Rwandan asylum system, whereas in fact we should be focusing more properly on the deficiencies of the UK asylum system that has enabled this outsourcing to take place. So there's a shift in the ways that this system is understood, from a critique of the Rwanda system to the deficiencies of the UK system, which has allowed this very, very significant backlog of people waiting, in some cases many years, for decisions on their asylum claims. And if we turn to this focus, if we try to focus on what's going on in the UK and the implications for the MEDP in terms of the future of the UK, I think there's a broader concern that the legal case, as was talked about in the webinar last week, really only highlights the situation of Rwanda. There is no judgment on whether it is reasonable to deport people to countries where they have had no previous connection. In fact, that was considered by the Supreme Court to be an acceptable way of deporting people. So this leaves open the possibility that even if it's no longer possible to remove people to Rwanda, there may be other countries which are investigated, are negotiated with by the UK government to remove people in these ways. Certainly, a number of other countries have already been mentioned by the UK government. In most cases, they have been very quick to distance themselves from this. I think it would be interesting to see how the experience of the Rwandan government affects the willingness of other countries to become involved in this sort of process. My guess would be that it makes other countries less likely to be involved. But the broader case of whether this sort of arrangement will help deter individuals from coming to the UK is another question that the Home Office itself is particularly uncertain about. In fact, it's said that it has no basis for judging whether this will be have a deterrent effect or not. One of the conclusions in the Home Office's own analysis, where they estimated that that the MEDP would cost £169,000 per individual who is removed, was that the policy could only be justified if it had a very significant deterrence effect. And there's very limited evidence elsewhere in the world of broad deterrence effects occurring at this scale. So I think we can be pretty uncertain about the wider implications of this in terms of their deterrence, and also in terms of their attempt to negotiate with similar agreements with other countries. But I think this broader question that Utara was touching on about the depth of the colonial evidence that we have for this highlights the fact that this isn't just about the movement of people, but it's also about reproducing unequal hierarchies between particular places. I think I'll probably stop there. Thank you very much.
Thank you, Michael. Many questions, but I will first hand to Felix.
Thank you very much, Nikki, and other speakers for your insights. I was asked 3 questions and I will intervene on those and in turn. And the first was around the involuntary nature of removals, my insights on that. And to answer that first one, I gave a voice to someone else because I thought it was more than fitting. And this person is Scholastique Mukasonga. She is arguably one of the most prolific Rwandan writers today, based in France. And in April last year, when this debate around the UK-Rwanda partnership was becoming a little bit more heated, she penned this article. I think she thinks in Kinyarwanda, writes in French, and the article was translated and published in The Guardian. And it was entitled, "As a Rwandan, I see what is missing from the asylum debate, and that is the voices of the refugees themselves." Her perspective is very important because Scholastique Mukasonga is a Rwandan, a genocide survivor. Her family having been killed in the atrocities. But also she has an experience dealing with asylum seekers, as she shares in her own article, in France, talking and as a social worker dealing with people in similar situations as those who are mentioned in the judgment, subject of the judgment. And that matters a lot. Because what she shares, therefore, in her article is this, that despite its, of course, a tragic history, Rwandan tradition has a very long history of hospitality. And she references the role also that refugeehood and asylum processes played in Rwandan pre-genocide, but also post-genocide times. And the experiences that also shaped a little bit some of the politics we are addressing today, of including this agreement. But before even the agreement, the politics that, for example, opened the door to Rwanda receiving many returnees after the genocide, but also of accommodating neighboring refugees from neighboring countries. But also we heard from MP Habineza about the background to the Libya scheme, among many others. So the article by Mukasonga tries a little bit to connect Rwanda's history of hospitality, the history of Rwandans themselves in exile, pre-genocide, post-genocide, but also policies that came to be negotiated after the settlement after the genocide, are somehow informing some of the attitudes that we have today, without necessarily romanticizing some of the issues as we tend to see in this debate. And what she shares also is this idea that maybe it's part of ways for Rwanda to address or to heal its own wound by caring for other migrants, but also it connects even to Rwanda's other attitude in other areas, such as, for example, peacekeeping operations, and among many others, in addition to many other reasons that may be informing those kind of choices. But with all that background in mind, she questions a little bit, where does the voice of the refugees themselves in this debate fit? And at that time already, she did what many were not doing at the time. We are talking about more than 1 year ago. So she went and talked to refugees somewhere in France, northern France. So many of those wishing to go to the UK, about this agreement. And according to her perspective, many were actually, nearly all had questions about this. Most shared that they were unwilling to back this argument without them having a voice into, let's say, for example, the removal. There were some who expressed some openness to considering Rwanda if other choices were worse than that. But it was clear that people who had no connection whatsoever to the African continent, or Rwanda in particular, were very much opposed to the idea. And to her, that was very important, in essence, for an agreement like this, that we have the voice of the refugees themselves. And of course, we know that there are quite a lot of different issues at stake for an agreement like this. When people leave home for different reasons, so we know the sacrifices they make, or the difficult choices they make. So when they reach, there are very many specific reasons why they go in certain given directions. And when they reach those kind of directions, we have always to look at what happens then. What are they seeking? What type of protection they are seeking? And then interrogate the question whether they can exactly obtain the same when removed to another place where they didn't have any choice whatsoever about going. And that was some of the perspectives, for example, shared by some of the people that she interrogated. Of course, by entering this argument, my contention is that Rwanda opened itself to the scrutiny that it gates from these debates, but also from the court ruling. But at the same time, many of us talking about that choice, the need for that choice, when looking at reading the argument, but also reading the judgment, we are very surprised by how much Rwanda gets scrutiny, rightly so, and it should get that scrutiny. And UK's policies and laws get less scrutiny. And I guess many other speakers before me have alluded to that. So I'm engaged actually preparing for this in a word search game in the judgment. And I was looking for the word Rwanda as opposed to UK or United Kingdom, or remove, and so on. Rwanda is mentioned 200 and some 8 times in the judgment, UK 75 times, and removal 71 times. To me, that matters a little bit. It's a trivial, of course, but also it speaks of how this is reflected upon in examining the burden. And I understand, of course, part of the reason why Rwanda is mentioned, many of the issues that were discussed were pertaining to the removal to Rwanda, but still, I believe that there can be more scrutiny needed on UK's outsourcing of responsibility to any other country, as was shared by many others before me. The second question then was a little bit about what after the judgment. Why is Rwanda seems to be still open to pursuing this further? Now, the why part is partly answered by the name of the agreement itself. It's called Migration and Economic Development Partnership. So in entering the agreement, basically UK linked its existing cooperation with Rwanda, development cooperation with Rwanda, to this agreement. And Rwanda is this country which still needs resources for development, including even in budgetary support, which has been, of course, decreasing how much it needs, but still external inputs are needed. So Rwanda still needs those kind of resources. So in addition to many referenced humanitarian reasons for entering the agreement, I believe also, of course, the agreement itself is very much eloquent on the why Rwanda can enter into an agreement like this. But more than that, of course, there is also real politic reasons that Rwanda did enter an agreement like this. Rwanda, of course, as a small country, developing country, still in the middle of Africa, needs to have a powerful country like the UK as an ally. And sometimes in international politics, we learn that there are many countries which are not necessarily able to say a simple no to some other countries, especially when they weigh different interests and what is at stake, including, for example, reduction of whatever they get from both in terms of economics, but also whatever political implication that may have in international scenes, including on geopolitical or regional issues. So it wasn't necessarily probably, at least that has been my reading, an easy thing for a country like Rwanda, which has long-standing cooperation with the UK under many different formats, including now within the Commonwealth framework. It wasn't necessarily a very easy thing for Rwanda to say no, but also including many other reasons, including the humanitarian ones, so that they tend to focus on. But we heard from, for example, Habineza, why that should not necessarily be a responsibility of Rwanda, and we should rather look for the UK side than for Rwanda. Now, I'll come back to some other elements that are often mentioned, but what now? What can happen? Well, from the reading of the judgment, of course, we understand that there are two focuses. One is the major criticism was around Rwanda's human rights record. How can you change that in order to make the condition acceptable for the UK? I doubt whether that many commentators have made it clear already that that's not something that you can fix overnight and then have the agreement now operational. So if the court, as the court lays out the record, I doubt whether Rwanda can do something in the short run that will satisfy the test. So that means then if there is any change that can occur at that level, it will probably happen in the UK, where they will change the goalposts on what needs to be done in Rwanda. Otherwise, the human rights record, at least, is something that always requires some given time to satisfy any given test that was done. And it's important, at least, to point out that on this particular element, and I don't know how much that has been made, UK has been a little bit more consistent, contrary to a number of other Western countries, and Nikki has written on that, I guess, among many others. A number of European countries sent people to Rwanda under a different framework, of course, the transfer cases for genocide suspect, under the idea that conditions had improved, and including the ICTR, so people could be tried there. So the human right record was acceptable enough a little bit to send people there. Canada, US, a number of Scandinavian countries, among many others. But UK has consistently refused to do so. So in this different case regarding migrants, this ruling a little bit meets a little bit in some way in a different setting that standing position. So how you change that, of course, will be something to be argued. Finally, I'm going toward the end, Nikki, 1 minute. So what then can happen? The second element may be, which was more the focus of the ruling about the systems. That's probably something can be done there. And I can see countries coming up to argument about how systems can be more kind of explained and made straightforward. And of course, that can have a benefit in Rwanda, but doing it only to satisfy the UK kind of case would be also probably would raise a lot of questions in Rwanda, because after all, Rwanda is this country which has a very strong, let's say, agaciro, kwigira, self-reliance, theological goal. So changing system in order to please another country, that's a typical case of neocolonialism. And I wonder whether that is a path that will be taken in a short run, rather than, of course, any other changes that can take a long time to hold. I'm happy to entertain any other questions as we go forward. Back to you, Nikki.
Excellent. Thank you, Felix.